Good morning. I would like to start off with a court proclamation to let you know that you are all very special and you are all very skilled. This goes back a while. In U.S. v. Prochner, the court point blank said that we're going to elevate sentences for those people who have special skills when they are committing a particular offense or crime. What was interesting about this case is they gave you examples of what a special skill was, and they noticed pilots, lawyers, demolition experts, and in Prochner they recognized computer hacking. Now, Mr. Prochner had the right to remain silent when he was arrested, but he apparently did not have the ability, because he gave a very detailed, I believe it was about a 12 to 15 page confession. So he got sentenced, and the court recognized, we're going to elevate your sentence based on this special skill, particularly since it was used to commit the crime. Well, then you go to jail, and your attorney goes to the appellate level and appeals that to the appellate level to say the district court got it wrong. We didn't have any special skills. Basically, it was he was like a script kiddie. That's all he was doing, and there were no special skills involved here. Unfortunately, they went back to that 12 to 15 page confession and said, no, the details he put in here, special skills, self-taught, and they elevated his sentence. So I start with that to let you know that you're all very special and very skilled. Clark's Law. You've heard Moore's Law, Clark's Law. Being a lawyer in this field, I find it a very exciting field. It changes very quickly. My presentation has changed in the last 3 weeks several times, thanks to many courts releasing a rash of opinions in the last 3 weeks. Your job is to explain what you do to lawyers at a third grade level. You need to do that because we need to take that information and explain it to a judge, a jury, or other people at a first grade level. So you need to bring it down and dumb it down so we can understand what you do. One of the aspects that I've always been told is facts are king. I did government contract litigation. I had a great mentor that said facts are king. So what you are doing is very fact specific, so you need to make sure your attorneys are asking you enough questions and that they understand what you do. Typically, most counsels I know, when you have a specific case, will focus on that case and ask a lot of questions and take a huge interest in it. So this is a very easy area to be interested in, but you need to make sure they're asking the right questions and the specific questions, because a passive honeypot can turn into a highly interactive eavesdropping wiretap device with just a couple changes in the facts. So you need to be specific on what you're doing. The other aspect that's very hot right now is the e-discovery rules. I'd like to say they're new, but they've been out for 6 months now. And that aspect's going to have a very large effect on what you do. Because when you're going and doing e-discovery, you can now get everything that's on someone's hard drive. Now, albeit the first thing as a lawyer I'm going to do is I'm going to say that's overburdensome, I can't turn everything over. But from that, you're talking about the metadata, and every lawyer loves to have the smoking gun. The document that just says, they knew about it, here it is, the Ford Pinto, the gas engine tank exploding, they knew about it. Everyone likes that smoking gun, and now your smoking guns are going to be found in that metadata. So you need to be able to advise attorneys on how to find it and where they should be looking for that aspect. The agenda. Like I said, when I first set up this, when you put your submissions in, you place in there what you think you're going to talk about. Thanks to the courts in this area, that has changed slightly. You're going to find when you get any kind of lawyer in this business, what they think is hot and relevant at the time is going to change. You try to keep aware of what other attorneys think is hot, and that's what I kind of tried to focus on here. Active response wasn't really hot, but then I guess there's going to be a conference up in, I think it's Boston, so you guys seem interested in that all the time, so I'm going to touch on that a little bit. I wanted to try to find some cases that what the courts are really dealing with, but also something that would interest you folks as security professionals, so I thought I'd look at the aspect of liability for stolen code. Jurisdiction's been very hot for both the civil aspect and the criminal side. Web searches have been busy, and of course search and seizure has just been all over the place. And Google has been just going like gangbusters. And I don't want to say there's aspects about people saying that Google's trying to brainwash us left and right. And I'm not sure what they mean by that. Because you've got to be careful exactly what happens with those folks. But we will talk about Viacom and Google on that. This presentation, and it's interesting, I'm actually going to stay away from the NSA litigation. Not a lot has changed. They dismissed one of the cases for lack of standing, which was kind of interesting. If you want to talk about that, I'm here. Please come up. I'll be glad to talk about it. I talked about it at DEF CON last year, and I talk about it from really a law professor's point of view. I'm going to tell you what the government says. I'm going to tell you what the plaintiffs are saying and let you come to your own decision on that. So if you want to talk about that, by all means, please feel free to come up and find me, and we'll be glad to talk about that. There they are again. All right, the disclaimer. This is interactive. Please feel free to ask as many questions as you'd like. Any comments, please feel free to state them. Any good lines, by all means, throw them out. I want this to be informative, entertaining, and informative. I've been to many of the lectures so far. I love you guys and gals because you make my head hurt immediately. I have several techie mentors that they figure the job they're doing, if they're doing a good job, I have a headache in 5 minutes of talking. If they're not doing a good job, then I don't have that headache. And so getting into the details, this is one of those things where sit back, listen. You don't necessarily have to read what's up there. The material has a lot more information in there to get you diving into some of the subject matter if you have something going on. If I've missed your prosecution, I'm sorry. By all means, please stand up and share it with us. Or your investigation that's going on, those are always fun. Please stand up and tell us that you're on an investigation, and we'll be glad to discuss it. My disclaimer, I am with the government, but I'm here in my own private capacity on vacation right now. So any errors that are in this presentation remain with me, and I do not speak on behalf of any government agency. And the problem with errors is this is being recorded. I apologize for that. Hopefully, I believe I'm a lot better live and in person than on the tape. And the nice thing about making a mistake now is it's caught forever, as opposed to Congress, when they're up there speaking, they can always ask to submit extended remarks so they don't sound as stupid in history as they do standing in front of C-SPAN. So the mistakes remain with me. One more disclaimer. One aspect. When I spoke last time, I kind of gave out trinkets for awards if you participated. I'm giving away a possibility of $1 million for correct answers. Now, we're going to talk about some negligence aspects and the proximate cause and the but-for aspect. How that works is, I have these $5 Caesar's chips. So if you answer the right question and you do all the right chain of events, you can turn this into $1 million. And these are pretty cool chips. I've got a Celine Dion, Gloria Estefan, the Forums, and this Magical Empire, which the guy at the cage thought you guys would really, really like. So you can ask for that. So, one more disclaimer that lawyers always put out. Who can tell me what this means? That's naked in front of a computer. That's the wrong one. Who can tell me what this means? Come on. Oh, see, there's too many. Someone's got to stand up and shout it. They could have had a $5 chip on that one. I am not your lawyer. Again, you get 3 lawyers in a room and ask them about one case, and you will get no less than 10 different opinions on it. I've heard once that, I guess it was a comment that, liberals kind of, someone who isn't gutsy enough to take a position one way or the other and stands in the middle of the road, and we all know what happens when you stand in the middle of the road, you get run over. Lawyers can be a lot like that too. You argue both sides. We're trained that way. So I'm not your lawyer. I'm going to tell you what I believe the case stands for here. After I'm done, if there are any lawyers in the room, 3 of them are going to come up out of 5 and say, hey, you got that wrong. Yeah, okay, great, wonderful. So we're trying to do this, again, from an aspect of what the case means, what it stands for, and that's where we're going for on this. So let's dive in. Again, I'm Robert Clark. If you're looking for Richard Clark, you slept through that probably yesterday. I did on that, so I apologize. For those of you who don't speak English, there's my name for you. On that, I apologize. I could not put my entire presentation in code. I'll have to try to do that next year. Stuff that just doesn't fit in. Again, this when you do your agenda, recent cases come out and they just jump out at you. And this was a recent case that came out And I guess the reason it's so important is because it's the first time a case specifically said that IP addresses are exactly the same thing as telephone numbers. Now, for many years, telephone numbers under Smith versus Maryland were held to have no expectation of privacy under the theory that when you dial the phone, it goes off to the telephone company. So you can't have an expectation in a telephone number when you dial, so they can go from the telephone companies and get it and continue to do their investigation. Well, now it was specifically stated that IP addresses are exactly the same. This is an interesting aspect because, again, if I'm doing an investigation and I get the telephone number and I go and do now a Google search, I can find out that you just called Chemicals Are Us, like if it's a methamphetamine investigation and the guy's dealing with precursor chemicals. So I can find that out. But, the other aspect of it, Chemicals Are Us, if I'm doing a meth investigation, it's kind of pointing in that direction, I've got it. But, with IP addresses, I've got to admit, being a government hack, but again, trying to be, very professorial, IP addresses 10, howtokillyourmother-in-law.com. That's a little more specific than, Chemicals Are Us. Chemicals Are Us has a legitimate purpose. There seems to be some aspects on that. Now, this court did specifically talk about IP addresses versus URL addresses. It specifically says we're talking about IP addresses. We are not talking about URL addresses, which identify a particular document within the website. So they did take great pains to comment about that, but it's an interesting aspect in the case of someone finally talking about that. This case I thought you would like. This actually, Mary Jean versus the Massachusetts State Police, kind of has nothing to do with the underlying facts of the case. The underlying facts of the case are a gentleman was being arrested for a misdemeanor, and 8 armed state troopers showed up at his house, came in, was arresting him on the misdemeanor, and asked if they could search his premise with a warrantless search. The entire thing was caught on video. Now, being a father of 3, I kind of like the way this was caught on video. It was caught by a nanny cam. So it picked up everything of this guy, poor schmuck, being arrested up in Massachusetts. And he took the video and gave it to Mary Jane, who had a website, and she posted it, of course. And the state police served her with a cease and desist order, saying that it was illegally obtained and that she had to take it down. So she filed to dismiss it under a First Amendment right that there was a inherent public duty and interest in this. And to make a long story short, she won basically because the court looked at it was illegally obtained, and she said no, the guy gave it to her, but she knew where she was getting it. And there were a couple cases that were out there before that where they were anonymously dropped off that to the newspapers to publish. And the court said no, I don't care that she knew that she was getting it from the suspect in the case. This has a high interest to the public, and we're going to let her publish it and keep it up. So it was an interesting case from that aspect on the website. As I mentioned, active response wasn't really a hot topic, and then I noticed this Bob Brown article came out and this conference going on. I guess it's, did I get this right? I think it's up in Boston. And I noticed some of the names had here, some speakers are going to be speaking at it that typically speak out here. So active response is always interesting. The aspect of active response is always that theory of self-defense and self-help, which is a standard that's been around for a long time. The one we always really focus on is the trespass to chattel, how it really applies to computer cases. And the thing I always point out on this one is that the law favors prevention over post-trespass recovery. And what that simply means is, if my neighbor keeps borrowing my lawnmower, they don't like it if I go into his yard, grab it back, and ram down his gate as I'm bringing it back. It's kind of disruptive. They would more prefer that I lock it up in my shed so my neighbor can't come and get it. So again, prevention versus recovery. This is where I'm going to ask for some help from my technological folks here. Last year at DEF CON, I had permission from Singrist to use their active response book, Aggressive Network Self-Defense, out there. And I had this in here. And the way my techies explained it to me, if I understand this right, doing a reverse DNS lookup. Actually, when I showed it to my guys, they started laughing. If I've got this correct, if I do a reverse DNS lookup and I'm running this, it's going to melt my machine. Is that correct? No? The bind and grabbing it isn't going to, shut down my machine? Okay, so I got that wrong. All right, so I've got the script going. So how in an active response, if I've got a reverse DNS lookup, does this code do anything as far as shutting down the machine that's running it and doing a reverse DNS lookup?
Are you doing a whole zone transfer?
You guys tell me. Yes, they're doing the whole zone transfer.
I mean, the guy you're zoning the transfer from, you're playing that as your, burden load on the block. That's how we are.
All right, see, because in the book, if I've got this right, and I apologize if I didn't copy this right, the way the theory works is he's doing, he's got his population here. He populates his DNS with several thousand of DNSs, and for the purpose of when someone's maliciously looking through it, that they're not going to go this far to find the 3 that are corrupt. Is this making sense for aggressive network self-defense? Come on, someone's had to have read the book. You guys haven't read the book? Who wrote the book? And the theory on that is, the point being, if I'm going to do something that's going to have malicious code on my machine, is there a different standard behind if I just put it on there and I know it's going to be grabbed and the guy's going to melt his machine, or if I have to hide it so it becomes harder for that individual to get to? Now again, the point behind it, if I've got a line of code in there that's going to melt the machine and that's the only line I've got in there, can you be sued for that? You're more likely to be sued for that because that looks like very much an intent. It's like, I just want someone to come to this box and I want them to get hit. Now, if I hide it in there, is that more self-defense? If they have to do more work, in other words, more work than a typical script kiddie's going to do, someone who's got a malicious intent to actually get in there and delve down into the system and find it, now I'm on more solid ground because that individual had to take more steps to actually get there. I'm going to get back to that aspect when we talk about kind of a liability for stolen code, because we're going to talk about a negligence standard and a duty of care. One of the active response or a nuisance case that actually came up that I did like was Universal Tube versus YouTube. Trespass to channel was a very big case in this one, and what happened on a motion to dismiss, they let the trademark claim go forward, but they dismissed the trespass to chattel. As you might imagine, Universal is a tube and pipe mill, and they've been in business for 2 decades. Prior to YouTube, they had a website, and basically they got a few thousand visits a month. YouTube comes up. How many visits do you think they get a day? 70,000. What do you think happens? Crashes their websites. So they sue. In the case, on the trespass to chattel, the court basically looks at them and says, we're really sorry that, your site's crashing. However, YouTube's not touching your site. They're not physically going to your site at all. You've got a bunch of mistaken folks going and crashing your site. So they dismiss the trespass to chattel claim. There's a nuisance theory going on. Nuisance in land, in real estate, is basically that aspect of your neighbor's trees growing over into your yard, and you keep asking him to trim it back, and he doesn't. Well, you go out and get your chainsaw and a ladder, and you just cut it right down. It's a nuisance. It's overhanging my property. I've got the right to do that. And in this, they said, that's a real estate theory. We're sorry that, technically you kind of are adjacent, YouTube, Y-O-U, YouTube, YouTube, but we're not going to recognize the nuisance in that aspect, and they're not going to carry it that far. So again, I wanted to try to get out of some of the issues that the courts are specifically dealing with and focus on something that maybe might touch and get you thinking a little bit in your business. So liabilities for stolen malicious codes. Now, I understand there's some hurdles to get over. If someone were to come and hack your boxes and steal different codes and things that you're working on, how can they trace it back to you? Again, reading Aggressive Network Self-Defense, one of the examples there had the individual actually sign his name at the end of the code he was writing. So I guess it's a kind of a pride thing. So whether that happens, we're going to have to get back that and get over that hurdle to go to that. And then the victim's going to have to sue you for basically having it stolen. So, can that happen? You can be sued for walking across the street. So basically, the example we have to look to is we have to look to analogies in the physical world. And stolen guns is, one of the best things that I can kind of come up with. And it really comes down to, like I said before, that negligence standard of what you're doing. Do you have a duty to protect that code from being stolen? Did you perform that duty or fail to perform that duty? And was it the proximate cause of the injury? Firearms, again, inherently dangerous articles. So you're looking at this, and one other aspect that we've got to look at in the courts is the but for. But for the fact that this was stolen, would this injury have occurred? Now, one of the aspects you start thinking about is, okay, well, we're talking about criminal liability, but when a criminal act is involved, that doesn't necessarily get you off the hook. Specifically, ironically, there's a case now up in Massachusetts where the son steals a gun and goes kills the cops, and the cops' estate is suing stepmom, or I guess it's the girlfriend, for basically allowing the boyfriend's son to get access to the gun. The gun was in a homemade case, and he unscrewed the screws to it, took the hinges off, and got the gun and went and killed the cop. So again, it says, wow, I had it in a locked case, and he got it. But the idea was they knew that he had some mental disturbances, that he had these tendencies, and so they should have done more to protect it. So with that in mind, when malicious code, and again, having been here and to DEF CON, the question becomes, what do you have to do to protect your code from someone getting in the wrong hand if you're in the security profession field and you're supposed to rip things apart, look at malicious code, test it against products? And the aspect becomes, what is that duty of care? That duty of care can change. It can change based on, again, your advertisement that code's there. We got that question a lot, and I think the honeypot guys deal with that a lot in terms of entrapment. If you're out there in an IRC chat room talking up the site, hey, it's easily hacked, is that entrapment to go to a honeypot? Same thing here. If you're out there and you're in chat rooms talking about your research, is that something that is starting to have a higher duty of care? If you're giving presentations on it, such as at Black Hat, does your duty of care become higher? And how inherently dangerous is that you're researching, from the virus, worm, or a rootkit? These are things to think about in the field that you're doing, and by all means, if you want to be the first one to kind of test the waters, let us know. All right, diving into what the courts have been doing. Terms of probation are always an interesting aspect for folks after they get caught. Typically, it's got to be related to the offense. And we see these a lot in child pornography convictions. Basically, you can't have any connections to the internet for about 3 years, computers, yada, yada, yada. Computer hacking crimes, we've seen it again. The prohibition on how long you can be around computers. One judge went so far as to say, and part of it is I want you to get some real world friends, flesh and blood. Mr. Volker here actually got a lifetime ban on computer equipment and the internet. On appeal, you're kind of like the court recognized, the ubiquitous nature of the internet. There's no way you can uphold a lifetime ban. You got to like a judge who uses big words like ubiquitous, because clearly he understands that things like wireless communications are more than just shouting at your kids across the yard. So he understood that the internet's pretty big, and Mr. Volker can't be limited to that. Jurisdiction cases have been coming up a lot on this. We've had a couple good civil jurisdiction cases and criminal jurisdiction cases. I like the Davidoff case because it's a civil jurisdiction case, and it deals with, if I've got this right, the plaintiff's family members, ex-husband or ex-wife, but you're dealing with exes. And whenever you deal with exes, it's going to be a good case. The ex-husband is in New York, and basically the ex-wife and an aunt and an uncle are in Florida. They hack his website in Florida and change his webpage to read Pig of the Year and wonderful, flattering things like that. So he sues them up in New York for the hacking of the site, where the actual effect of it came in. And the argument that they start stating is the fact that telephones, fax machines, internet communications are so prevalent now that there's enough contact that I should be able to haul these people up from Florida to sue them in New York. Well, the court goes back to, this is the greatest, oldest case about minimum contacts and how I can get you into court as international shoe. We're taught in law school that the first thing we do in the morning when we go into our law office is sleep. And but when you see the partner walk by, you've got to shout something out to make them think you're working. You always say, well, international shoe. And they're like, okay, the kid's working, good. It's minimum contact. You have got to have some contact to the forum that you're being sued in for us to get a grab on you and haul you in here. And in this particular case, they held that he did not have sufficient contact with the state of New York. Just because the act was felt in New York, if that's true, whenever you hack a website, it could be felt in all 50 states, which means you're opening yourself up to being sued in all 50 jurisdictions. So they said, that's not enough to bring these people up here. You're going to have to go take a Disney World vacation and sue them down there. With that, you have good old Mr. McCaig, who decided to go to Hawaii and take a whale watching trip. I'm not sure if alcohol was involved, but it was apparently a rough day at sea. He fell down on the boat, broke a couple of vertebrae, and wanted to sue them. Now, he's from Pennsylvania. And ironically enough, I was in the elevator with someone, and he's got a tag on that says Stop PA. And I was joking, well, maybe this is the case they were talking about because you want to stop Pennsylvania from bringing people in and suing them. Now you're talking about interactive and passive websites. Now we're starting to get some minimum context going here. How much interaction do we have on this website that's going to subject us to jurisdiction? How much business am I getting from different jurisdictions where I can be brought in and sued there? And on this one, basically they said that this website was not targeting Pennsylvanians per se, so we're not going to haul them all the way here to defend the case. So on the civil side of life, those are the things that we're looking at.
Robert,
Yes.
can I ask a question?
Sure.
It has to do with websites, malicious code, which you had to slide on, and all things the state of Pennsylvania. Theoretical case. Say you set up a hacking site, website, where other hackers can post malicious code on that site. And that malicious code is used to cause damage. The suit is brought against, say, that hacker. Can you, as the operator of that website, also be held partially or fully liable for disclosure of that malicious code?
All right, now this is the fun part of watching your webcams again, cast it back. So I'm going to repeat it because I don't know that it actually got heard. Okay, so I'm setting up a hacker's website where hackers can come and post code to that website, malicious code, and I'm kind of the moderator of it, and other people can come and download that code, look at it, and something happens, they download it from my site. Can I be liable for that? What do you think the answer is?
The reason why I bring this up is in my state of Pennsylvania, there was an analogous case where there was a hunter on private property who accidentally shot a pregnant woman about 2 miles away. And the jury found that 90% of the liability went to the hunter for that accident, but 10% of the liability went to the owner of that property, even though he had nothing to do with the actual shooting.
All right, and again for the camera, he analogized it to a case in which a hunter was out and shot a woman on, I guess, his private property, and she was quite far away. He was held 90% liable, and she was held 10% liable. Contributory liability. He's 10%, she's 90? Hunter 90%. Oh, the property owner? Interesting aspect. When you start talking about, and I'm going to go back to your example for the web page, because the aspect on this is, can you be held liable? It depends. Sorry to go there, but you're talking about a jury, and you're talking about, advancing arguments of contributory liability. Now, the law aspect of it for a couple things, which we're going to get in for websites. All right, when you're the website and you're posting it, are you liable for things that are posted on there? The speech aspect of it? Typically not. We're going to get into that aspect of it because basically it's the same thing as First Amendment and the publisher. You're not the publisher of it. The people posting it, they're the publisher of it. Now, there's some exceptions on that in terms of infringing information, things of that nature, and we're going to talk to some of those exceptions. When you start becoming interactive to that information that's published on there, so jumping ahead, there's a case, the fair housing case against a site that was setting up for roommates. And it's the typical aspect. Post, what you want for your roommate, and you can use the site to find a roommate. Well, on this one, if they just done that and let the people post what they want, they would not be liable for the infringing material. And this one basically violated the Fair Housing Act in that you can't discriminate when you're putting it up there. I mean, what they created was drop-down boxes with questions. Seeking only cat lovers, dog lovers, computer hackers only, and as you can imagine, Fair Housing Act, anti-discrimination, they started having some of those aspects that crossed the line, and they shut down the website saying you violated the Fair Housing Act for that. Interactive, they were responsible for some of that content. So now, if I'm going after, again, the site that's got the malicious aspect of it, Are you just posting it? Have you modified any of it? And from that aspect. Now, right off the bat, okay, this is, law practice 101. I get harmed by it. Who am I going to file suit after?
Deepest pockets.
Who said that? Stand up here. You want, he said deepest pockets. You want the Magic Empire, Celine Dion, Gloria. You got the Magic Empire. There you go. Outstanding. Deepest pockets. I'm a Chrysler kid. I grew up in Michigan. My dad worked for Chrysler. Where does Chrysler get sued all the time? It's, I can't even remember. I'm from Oakland County. Wayne County. It's Detroit. Downtown Detroit. Why? Very poor, deep pockets. Let's give a little money out to the little guy. So you're going to sue the deep pocket. So if I'm suing this for the website, I'm suing the website, and I'm going to, through discovery, try to find out who also posted that malicious code in there and haul them in too. So I'm going to put them all in. Now, who's going to be responsible? I've got theories of contributory liability that I can throw out there. Again, contributory liability aspects of life means who's going to share most of the responsibility. I always tease my wife when I was clerking for a judge. There was a product liability case over a bad haircut. What it was the gal was working on a turret drill. And the turret drill basically has about 5 different drills, and it rotates around to create a product. And obviously, you've got the safety mechanisms on there, so you can't be close as you're pulling it down. And being a good company, they jerry-rigged it so they could work faster. And the gal's hair got caught in the turret drill, and it scalped her. Contributory liability. I was watching the guy's closing arguments, one of the best ones I've ever seen. The guy was really smooth. They were suing for like $2 million for a bad haircut. And he goes and he said, look, if you believe that my client's liable, it's not for the full $2 million. And he goes into her earnings and everything. And he goes, we might be liable for a certain percentage. And that's what the verdict came back to. Basically, the gal who got the haircut was liable for 97.5%, and the company was liable for 2.5%. But the verdict was $4 million. So when you're talking numbers, that's the aspect. So if you're setting up a website, your first defense is going to be, again, the aspect of kind of free speech. I'm just here letting them post whatever they want. I'm not liable for that. Code is speech, several cases have said, so I'm just going to post it, and that's it. Now, is that going to prevent you from being liable and going into court? Not if I was the attorney. I mean, again, back to the deep pockets aspect of life. All right, interactive aspects, and that's kind of what we're talking about with that. This particular case, again, it was not an interactive website, so they weren't hauled into court. Hagasmith, this is a criminal case. These are the online pharmaceuticals. The aspect on this one was a Stanford freshman online ordered a bunch of Prozac. You can kind of see where this is going to go by the bottom line there. The way it works is he orders it through JRB Health Solutions, a Florida company. They have subcontracted with a Colorado physician to fill the prescription. They then get a Mississippi-based pharmacy to issue the prescription. So we're talking, and it goes to California. So you got a whole bunch of things going on here. Kid dies, and San Mateo is going to bring a criminal case against the doctor, not for so much the death, but for practicing without a license in the jurisdiction on it. Now, his whole thing is, I wasn't practicing in the jurisdiction. I wasn't even within the jurisdiction. Again, going back to that minimum context that we were talking about before. In this criminal case, the motion came up kind of a preliminary motion to dismiss, so he doesn't have to go forward and show up in California to the criminal prosecution. And the court held here, by a preponderance of the evidence, it is foreseeable that when you issue a prescription, it's going to go to several different states. So it's foreseeable that you need to do more than just be filling the prescription without any research to find out who it's going to and the context that go with that. So they're going to haul him into California to stand trial on practicing in California without a license. Again, his big thing at all times, I was in Colorado, and basically it's called constructive presence, and they're going to bring him in. I bring this up as a quick hitter in the matter of searching Yahoo. With the Patriot Act, which everyone No comment. The Patriot Act modified some of the search requirements. It basically gave jurisdictions the capability to issue a search warrant, which is good across all jurisdictions. And this actually was the case. In Arizona, they issued a search of Yahoo in California and said, yep, you can go and take this, and it's valid, so we don't have to worry about that. Web-based software. Kind of a little bit going back to the hacking site. Many of us have used TurboTax or different products such as that. In this particular case, the company was a bankruptcy software website, and this kind of stands for the aspect of watching that sales puffery, what you are advertising and what you're actually doing, because their interactive site, combined with the sales puffery, had them violating and practicing law without a license on this. And that's what it is. The decision, as the court says, stands for an overly expert program coupled with poorly chosen statements can expose the vendor to a claim of practicing without a law license. The kind of difference on this one, again, TurboTax kind of helps you plug in decide to choose which forms you want, and this one did too. Specifically, you put the information in, it chose what forms to file for the bankruptcy. Plus, with the words they used here for the sales puffery, basically said, nope, you're practicing law without a license, and we're going to let you be sued for that. This goes back to the web page aspect. Universal Communications was suing Lycos because an anonymous posting on it defamed and slandered them, saying that their financial state wasn't as good as it should be. They sued Lycos basically for it. And again, the court said, nope, under Communication Decency Act, they're just posting the information. They're not liable for it, for what's being stated in there, so you can't bring a lawsuit against them on that one. So, again, can you be sued for that? Yeah, absolutely. For the hacking site where you're inviting code to come in, will they prevail? Again, everyone in this room knows several different cyber lawyers. So if I were you, I'd be either getting Mr. Carr out of George Washington University, or kind of like what I'm the warm-up act for, Ms. Granick out of Stanford to represent you to make sure you're not liable for your hacking website. We already talked about the fair housing case on this one. And again, this was more interactive. Instead of just posting the information, they had the drop-down boxes for specific categories of roommates that you were looking for. So again, this violated the Communication Decency Act, made them liable for what they were posting there. The difference being they were responsible for some of the content that was actually coming up while they were doing it. All right, let's turn to some of the fun cases that you want to, the seizure of your computer equipment is always a hot topic. Seizing it, how you seize it, search methods. This case, in re Forgiano, your equipment's going to be seized. Is it at home? Is it at the office? It's a fun aspect. I like this case because basically it's the old aspect of college students, one's harassing another college student. So that college student goes to the system administrator of the school, they kind of find the IP addresses, they turn it over to the cops, cops do a little investigation, find out the IP address belongs to the student, go to the house with a search warrant to seize all computer equipment. So they seize all the computer equipment, to include grandma's TurboTax and everything that's up there, and they take everything out of the house. So the parents, of course, file a suit to get their equipment back, saying, hey, okay, so my kid did this, great, can I have my equipment back? And the court said no. Based on the totality of the circumstances, the search warrant said all computer equipment. I don't know that they're using the computer in the basement to cause the stalking and harassment. They might be using grandma's computer up in the guest bedroom to do it. So we're going to take everything and we're going to hold on to everything. You cannot get it back. Getting the data back, that's the fun aspect of the data back from that. When you're, getting mirror images and things of that nature. And this goes into the search methods, which is kind of down the road. One of the hugest complaints that I've heard of is the processing time for certain three-letter agencies to process an image and search the computer, and that it's long. Now, that has happened. Cases have come in, and courts have told those particular law enforcement agencies, search the damn computer or return it by this date. So they have occurred, and that's the aspect of it. Again, Your attorney has got to be savvy enough to say, this thing needs to be searched by a certain time frame or it has to be returned, and that's the process that they're going to pursue. Question. The question was, can I get the data back on that one? So sorry about that. I did the answer before that. Sir?
Has anyone talked about that being a double standard for the small consumer business versus the large enterprise? Because the large enterprise may be using a single IP address to house all of its network going out to the internet, but you can't take away everything in that business because of one harassment case.
Okay, so if I've got the question right on this one, the question is looking between the large enterprise against the small consumer, because when you want to search or see something from the large enterprise, you can't take that away as opposed from the small consumer, that you can take that away a lot easier. Is that correct? All right. Obviously, from that aspect, with law enforcement and law enforcement investigations, you're going to be working on different aspects of the method to do that ahead of time, hopefully, from that aspect. So when you're talking about what I've seen so far with large enterprises, what they do is they go in and, to some extent, with a very overwhelming team, hopefully, to go in there and image what they need to preserve that aspect. Some large corporations, again, have actually had things seized from that. Small consumers, so who's more strong or weak here? Yeah, your large enterprises, again, personal opinion. And I've seen this more from other practice areas. Large corporations always have a tendency to fare better than mom and pop.
So mom and pop can't reference another case that's been applied to a large enterprise?
Mom and pop, questions, can mom and pop reference another case that's been, absolutely. And that's what again, we're talking, this is the law school aspect of the question here. Mom and pop, what resources do mom and pop have to know who the attorneys I'm supposed to get? Because again, mom and pop, for fear that mom and pop are running, the small bakery or the deli, and, teenage son is, caught up. And they come in and they take everything, what are typically mom and pop going to know? Okay, I've incorporated, to lower my tax aspect, and I've got a lawyer who helped me do it. Okay, so now I call that lawyer. Hey, my son's, just had my computers seized because he's caught up in something, whatever it is. Is that lawyer going to know what to do? Is he going to be smart enough to say, this ain't my field, which ethically, lawyers, I can only take a case that I'm competent to take, or I have enough time to get competent to do the research and the representation on that. So, again, people like everybody else. Is that lawyer going to say, I'm going to go find a referral for someone who knows what they're doing in this area, or am I going to do the research? So you're taking on a whole aspects of whether mom and pop and large company are going to have the same resources. Typically, attorney knows what he's doing, going to be able to cite, hey, I've got a business here, they've got to get it back, work with the prosecutors to image it, to get that back. I mean, these are all the things that you're going to be doing for your client to get it back.
Let's say your hard drive got seized by the government, but you have hard drive encryption on it. Can you not give your password to the government under self-discrimination?
All right, so the question is, I've got a hard drive, it's encrypted, and can I give the password to the government? Can you not give it under self-incrimination? So, well, let's go through the facts. I've got your hard drive, it's encrypted. What's the password? Do you think that there's a violation of the Fifth Amendment right there? I would say yes. At that point in time, you have the right to remain silent. They see whether you have the ability is the next question. a lot of there's been some great cases in here jumping ahead on consent and aspects on whether when police are right there. There's a case in revoking consent where they're investigating child porn. They contact the guy. Hey, come on in and talk to us. And so the guy does. Mistake one. But he calls back and he says, the computer you want to see? Oh, God, I reformatted it, so I wiped it clean. Well, come on in and talk anyways. So he does. So, and through the conversation, they're like, well, can we go to your place and get the computer? And the guy does. And as they're leaving to go, he signs a consent form for the search. And he says, I'm not sure. What's the penalty if I get caught up on all this? Because there might be something on there. And they kind of, tell them what the range could be, but, they're not lawyers, and if you want to revoke consent, you can. And he goes, oh, no, not now. And they drive over to another agent's office to pick up this other agent to go to his house. And even, when they stop there, he goes, oh, I think I may not want to consent. And the guy's like, well, think about it, and when we get to your house, you can decide then. So both agents get to the house, and they have the discussion again there. He's like, I think I'm going to, I don't know if I want to consent. And the cop does the classic, well, you can revoke consent, but we're going to stay right here, and we're going to go get a search warrant, and we're going to get the machine anyways. So the guy goes, okay, go ahead. And in the case, the court opinion said that was not a threat. And the reason was because when you simply state what the legal process is, which is what they could have done, it's not a threat. They were just stating a fact. Like, sky's blue and I can go get a warrant. Like, it's just the normal course. So again, when something's seized and all your agents, if I'm in Massachusetts, 8 armed agents are standing there, heavily armed, and they ask for consent, that's the aspect. Yes?
What is your take on the admissibility in court of live forensics evidence? That is, when instead of doing like a seizure of computer, performing a full analysis of the data, you just connect remotely to a live machine, and you collect evidence from there, so you typically don't have full chain of custody and that kind of stuff.
Okay, which aspect? The question is a question going towards the aspect of the admissibility of the forensics done on a machine. I'm kind of maybe not understanding. And you're saying connecting it and actually running the forensics in court live as it's happening right there? No. Running the forensics on it and then having someone testify to as running the forensics. I sat through a couple of the forensics presentations. They were talking about products and possible problems with them. Is that what you're referencing?
It's kind of the same, that is, traditionally in forensics, you just seize a drive and perform, do an image of it, and you just analyze it, and through that, you maintain a very clear record, and you can prove to the court that you didn't tamper with the evidence.
And you're raising a question of chain of custody, how good they're doing the forensics, how much they're noting it. Again, this is going to be very prevalent for both civil cases and criminal cases. It's becoming very prevalent in civil cases for the metadata that you can grab from criminal cases. The aspect is expert testimony, and is it pharmaceutical, Maribel versus Dow Pharmaceutical is the standard. Now, this comes back to, and there's a lot of cases out there in terms about doing forensics. And while you're doing forensics, particularly in civil litigation, while you're doing it was the plaintiff's expert and the defense attorney, sitting there side by side when they're doing it. You've got, in the civil cases, doing the full expert case on it, sharing your results with the other side, taking the depositions, going back and forth. So as part of that from a civil aspect, as doing a forensics aspect, how comfortable I am with that evidence being put in. Scientific evidence is very interesting. The idea and the standard behind it is that an expert witness is supposed to help enhance the knowledge of whatever is the subject to the jury. It's got to be credible in the field, recognized from that, and again, add to the jury. Clearly, what you folks do for computer forensics is a specialty that is required because, as I go back to my first statement, you've got to explain it at a 3rd grade level so people can understand it at a 1st grade level. Civil case, okay? All right, I have 3 coins left. I need someone to stand up and put their hand up on this one. In a civil case, plaintiff versus defendant, experts, who's going to win? Guys, come on. It doesn't depend. The person with the most money who can hire the best expert is going to win. All right? So, I'm sorry, what was just set up in front, if I heard correctly? I heard it. The DNA case, a famous DNA case that came on, that you're talking about, a murder case with DNA evidence that comes in. You get an expert, an expensive expert who knows his stuff forwards and back. You stand a greater chance because you're going to diminish what that other expert does. That's the same thing when you're looking at it. So as far as civilly, forensic evidence coming in, you guys are very important. Again, the attorneys have to ask very fact-specific cases. They have to be involved early to know what's going on, and you have to educate them, again, to know what's going on. Can this be done? Absolutely. I spoke before, I'm very self-deprecating at times, and I've had people say, stop being so self-deprecating. Folks, I'm not a rocket scientist. But you've seen those American Express commercials? An FMU 140 bomb fuse made by Motorola with a pitot tube that gets released as it's going down to check the airspeed going through. And if it doesn't get released because of the circuit that's in there, it won't go off and it's a dud. And the circuits are actually put in, and when they were initially put in, they were put in by hand in a factory down in Mexico. And that was the first production, the first test that we went through. And as they went through, they changed it. And now they're being machine implemented, and that caused the weakness there. So the circuits were breaking, the pitot tubes weren't going out, and the bombs didn't go off. Wow, are you a bomb expert? No, but I stayed in the Holiday Inn Express last night. I don't know stuff about bombs, but the chain reaction. So again, it's kind of like Aladdin. So I got kids again. He can be taught. I mean, we can learn, and it's your job to break it down so we can understand it. So the forensics aspect of it, you've got to break it down. And that's the thing. Criminally, the criminal aspects of forensics, imaging of that nature. Personally, I think that's a tougher standard to bear and have to deal with. And part of that is because of the fact that you're now talking a deprivation of your liberty as opposed to anything else on that. But there are still the same standards that they have to go through. The end case presentations that were done yesterday were very enlightening. That's why I was there. Very interesting aspects. Again, what's the weakness in what's being done? What can I attack? And while I would like to say in confidence that the job is they have to prove you guilty beyond a reasonable doubt, you ask any defense attorney, I have just got to introduce that doubt. Where can I introduce that doubt? And that's what we go with. So I noticed the time. We're going to go into some third-party consents because that's been very big. I'm going to try to go through this a little fast on this one. The materials in here, I am going to try to, this material I don't get to, I'm going to bring to the forefront for when I speak at DEF CON on Friday, so if you're hanging around, so I don't give the same speech twice. And the same, you'll hear the same jokes. I apologize for that. I'm limited. Third-party consent's a big thing. It's where you've got people living in different places. This is a military case. It's a case where the defendant is going to buy a computer from his roommate. And he takes the computer, puts it in his room. They have set up a LAN in there for gaming and file sharing. And so the guy he's going to buy it from, he hasn't paid him yet. And the guy still performs maintenance on it. And of course, performing maintenance, he clicks under My Music, finds images of child pornography, and does what anybody would do, calls the cops. Cops come and arrest the guy, bring him into court, and the question is, actual authority or apparent authority? Actual authority is, hey, it's mine, I'm going to approve. Apparent authority is, well, he's got common access to it. The individual who owns it hasn't done anything to restrict his access to it. He's got permission. Okay, it appears to the cops the totality of the circumstances that he can approve. So the search is good, it stands, the guy goes to jail. Now, there's a fun case that just came out called U.S. versus Andrus. And the reason it's fun is because this is also known as it's the 91-year-old doctor answering the door in his pajamas. They're investigating his 51-year-old son. Now, he lives at home to care for his elderly father. And they come, and after 8 months, nothing has happened in this investigation. So they go and do a knock and talk. And there's Dr. Andrus, opens the door, 91, standing in his pajamas. Now, they do not talk about if he's frail or his faculties or anything like that. But through the course of the investigation, and you got to remember, the doctor pays the internet bill in the house. The email address looks like it's got his initials on it. So there's some aspects for it. They say, hey, we know a couple people live here. Do you have access to your son's room? He says, yeah, I do, except if the door's closed or locked, I knock before I go in. And they said, can we search, the door's open, they see the bedroom, can we search the computer? They go in, they're looking at it, and then finally something, the facts I think I might have missed, but it's not clear. They stopped the search because they found out that the doctor really doesn't use the computer. And then Ray comes home, of course, and there's cops standing in there. And again, it goes back to my previous point. Can we have consent to search the computer? It's kind of like 4 cops are standing here, right here. Yeah, go ahead. On that one. So the district court looks at it from the apparent authority aspect of life. Again, going back to what was there for the investigation. On this one, at the appellate level, it starts looking good because the appellate level starts looking at computers and makes the comment that for most people, computers are the most private things that they've got. So it's starting to look good for the home team, like we're going to go in a different direction. Starts comparing to those things that we have a higher expectation of privacy in. And then I don't know what happens, but then it goes in the other direction. And they basically say, nope, we're okay on this one. By the way, they used EnCase on this and got right past the password-protected files on it. And again, it's an interesting aspect what courts are willing to look at and what they're not, what they recognize. On this one, they said password protection is not so pervasive as that we expect cops to know it's there. In this day and age, my question becomes, if I'm a ne'er-do-well kind of individual, which files on my computer am I really going to password protect? The ones I don't want the cops to see. And the cops are investigating this, so it's kind of becoming a standard where EnCase can look to see if they're password protected and let them know right there. So I think this is an interesting standard. I think it's going to get kind of checked here pretty soon to see if they're planning on sticking with that or if they're going to force things to change a little bit. Revoking consent, I talked about a little bit earlier. That was Andrzejczyk. Again, this is the aspect where he was driving all over town with them. And they gave them the comment, well, if you are going to revoke consent, we're going to go get the search warrant. And the court held, hey, this is not a threat. It's just a fact of life. Get used to it. So, the copyright. Ziegler's a search. This is a great case. So that's what I'm going to actually probably end with this one. We're not going to talk about the Viacom Google copyright case. Although I will say, everything that Viacom has alleged in their complaint is the exact same thing that happened in the Grokster case. So it's going to be interesting to see how that plays out. I think it'll settle before it goes to court. They were trying to settle before they went into court. So my guess would be that's the direction it's going to go. Ziegler, the left, makes the comment, and when I say left, I say that's the defense attorneys, the rights, the prosecutors. I'm not saying where you want to stand. The left has this case as it's a panic. There's a rash of cases with no reasonable expectation of privacy in your workplace. You're going to be subject to arbitrary, capricious searches. The right says, hey, they got it right. The employee has a reasonable expectation, but the employer who owns the machine can consent to its search. The reason this is such a great case is because the CFO is the one that consented to the cops for the search of the machine. The defendant was not liked in the company. And so a suspicious tip was given to the cops that he had child porn, I think it was, on the machine. So you've got a suspicious tip, defendant's not liked, and the CFO gives permission for them to image and search the machine. The CEO does not like this law enforcement agency that's involved. Discretion says I shouldn't mention it, FBI. And basically, absolutely hates them. Never would have consented to the search for this, for the aspect of it. That's why this is such a great case. Because back to my actual and apparent authority, who has the authority in a corporation, in a business, to consent to the search of it? You have the CFO, that's apparent to the cops. That seems pretty high up, and the judge bought it saying, yeah, apparent authority, he apparently looks like he's got it. Totality of the circumstances, you can look at it. So it's an interesting case. Again, the facts make the case because you've got the CEO who never would have consented, and that's why you've got the people debating the aspects of reasonable expectation of workplace searches. Very quickly mentioned Viacom's lawsuit going on there. They have mentioned all the right words in their case. Brazen disregard for that. The fact that they copy the material into their own software. They're directly making a profit on this. YouTube's coming back, or Google's coming back again, claiming the aspect that we're just the publishers. We actually do remove infringing materials. So it's going to be interesting to see how this plays out. It does seem like it falls squarely on the Supreme Court's decision of Grokster, and it looks the same, and they are making a huge profit. The difference, Grokster also said that they had the smoking gun. Grokster, point blank, was going after Napster's clients. They actually had emails saying, Napster's falling down, we've got to quickly move to get these customer base. You don't have that in YouTube from what I see so far, because I don't know anyone falling down. Again, I suspect this will settle prior to actually going to the court on that, so we'll have to keep up to speed on that. And finally, since I'm right at 11 o'clock or 2 o'clock according to Eastern Standard Time, deorders were basically the government going to get your emails on stuff that was in storage for more than, I think it was 180 days. The reason Smilin' Bob's up there is the company. If you know what Smilin' Bob does, it's a herbal company that helps with certain personal problems. The actual real person is Steve Warchuk. Now, he got them. They got an injunction. So to get your emails, there's certain standards that are not what they used to be. One of them is to give you notice that they're going to get your emails from that aspect. The case is still moving forward in the criminal aspect. His co-conspirators actually pled guilty, which I believe was his sister, is married to another guy in the company. They pled guilty, so it's be interesting to see how that goes. It's 11 o'clock. You're supposed to go on break until 11:15, so enjoy yourself, the conference. I am around. Any questions, please feel free to come up and ask.